Buddy. Before I hand it over, I'd like to go through a few housekeeping items. Number one is we will be sending you a copy of Chris's PowerPoint at some point. I think it'll probably be emailed to you. We are recording this, and it will be available on our website, and that website is score.org/Akron Canton. We're asking that if you have any questions for Chris, I don't know if Chris, did you want to take these as they come up, or do you want to hold them off till the end?
I would probably say hold off to the end.
Okay.
I generally don't have a problem if someone has an issue that pops up that's part of the general discussion.
Okay.
My issue is a lot of times the questions are very, very fact unique, specific to that person, and
Okay.
it sort of doesn't help the conversation for everyone, and it
Okay.
delays things maybe.
Great way to look at it. So feel free to throw your questions into the Q&A feature, and then Chris will answer them at the end unless they're pertinent to what he's talking about right now. And if use the Zoom chat feature, if you have if the presenter asks you any questions, or if you want to talk amongst the other registrants. Lastly, there'll be a brief 2-minute survey that we'll send out that will hopefully give us some ideas how we can make this more beneficial for everyone. So, okay, next slide, Gwen. My name is Ed Cook, and I am a SCORE mentor in Canton, Ohio. Um, been a mentor for, maybe 12 years. I retired from PepsiCo. This is the way I keep away from stay involved with things. So, but SCORE is a national nonprofit organization. It began back in 1964 down in Dallas, Texas, and we now have over 200 chapters in the U.S. We mentor startup companies, existing businesses, whether they're for profit, nonprofit, and requesting a mentor is extremely easy. It's really just a few clicks. And you can see by the big blue dot there that small businesses that do receive 3 hours of mentoring report greater success. Uh, next slide, please. Our mission is pretty simple. It's to support small businesses, and we do that by providing a couple things. One, we provide free and confidential mentoring to all small business owners and entrepreneurs, and we provide free educational workshops and webinars on topics that small businesses can benefit by. That's what we're doing right now. Our belief is that small businesses impact the national economy and they drive job growth in the community. Next, please. We do have that number needs updated. We have about 8,000 volunteers throughout the country, and we serve 1,500 communities. And each of our volunteers have a very unique and knowledgeable business skill set. Next slide, please. We do sign an annual code of ethics. It basically says that we cannot benefit in any way from the client, and that client information is confidential and protected. So, next slide, please. Our services are free, and there's really three reasons for that. One is we're a resource partner of the SBA. And there are also a great number of local sponsors that are very generous with their community money. And lastly is our volunteers that do this for free. Next slide, please. In Cleveland, we have a number of sponsors. We have the Cleveland Neighborhood Progress, Capital Growth, Truax Law, Consumer Community Star Credit Union, the Lorraine Community Foundation, Key Bank, PNC, Wells Fargo, and Chase. Next screen, please. And here's our website, a QR code for our website. It's like I said, it's pretty easy to request a mentor or to become a volunteer that we're always looking for as well. With that, I'm going to ask Gwen to stop sharing and ask Chris to start sharing, and we'll get things rolling here.
All right, I have this banner on the top of my screen and I'm trying to figure out how to. Oh, here we go. There we go. All right. My name's Chris Corpus. I'm a local business attorney here, located over in Lorain County. Um, I've been doing this for heavens, going on 26 years now, and have my own firm. So I'm an entrepreneur, just like you folks. Um, and I worked at a law firm for, what would it be, 16 of the years that I started practicing. And then I left in 2016, started my own firm. So I'm going on my 10th year anniversary this May. And excuse me. Assist clients with all things business matters, help people buy businesses, sell businesses, draft contracts, review contracts, set up businesses, whether they're single owner or multi-owner. I help clients buy and sell commercial property, lease commercial property, and trademarks. Today, as you can see from the title page, we are going to talk about contracts, which is important. There's so many issues that are going to your business is going to face regarding contracts, whether you're the one providing the service, or you're receiving a service, or you're hiring an employee or a contractor, whatever it may be. Contracts are going to be just a regular transaction while you're operating your business. So today we're going to talk about what are the elements of a contract? What does it take to form a contract? What are the couple of types of contracts? What type of content do you typically see in a contract? And then payment terms. So then for the elements of a contract, all of these need to be present in some shape, form, way, or another for you to have an enforceable agreement. So that's going to be your offer, an acceptance, consideration, capacity, and the subject matter of the contract is legal. So an offer, ultimately, um, what are you looking to try to sell? In this, just a couple of very basic examples. Do you want to buy my car? Right? You're making an offer to someone, and then ultimately, someone's going to have to respond with a yes or a no or counteroffer with a different amount that they're willing to pay. You also have the ability to make an offer, which would be, I'll give you $500 if you drive my car to Akron. And in that scenario, I don't need to say yes or no. I just need to get in the car and drive it. And my actions are the acceptance of that contract. So there's multiple ways you can craft your offer. That is your contract that you're offering to the offeree, the person receiving the offer. And there's multiple ways that you as the offeree, the person receiving the offer, that you can accept that contract. So, in what manner can you accept the offer? It can be saying yes. It can be saying, you can make a counter offer. So if you make a counter offer, that ultimately rejects the offer, the original offer, you become the offeror, and then ultimately now the offeror becomes the offeree and is the one receiving your counter offer. So if you say, I don't want to buy your car for 500, but I'll buy it for 450, right there, you made a counter offer and that counter offer has rejected that original offer. And then it's up to the person who made the original offer to determine if they want to accept or not. Once you've made your counter offer, and if the seller comes back and says, no, I'm stuck at 500, you're like, oh, okay, I'll take your $500 offer. You're like, oh, no, that's no longer on the table. You already rejected it. So that the counter offer in and of itself acts as a rejection of that original offer. And does your offer, specify any particular type of acceptance? Acceptance within a certain time period. Could you say, in order to accept, you must send an email, a letter, whatever it may be, to this person, my lawyer, whatever it may be. So as the offer, or you're the master of your offer. You can put whatever terms in that you want for specificity purposes. You could even say, I don't check my email. I don't check my text messages. I don't want to be involved in this because I'm probably going to miss it or I'm too busy. I'm going to be out of the country, whatever it may be. You can specify the terms that are going to be an acceptable acceptance of your offer. So in the scenario where I'm going to offer my car for sale for $500, your response is, let me think about it and I'll get back to you. Do I have the ability to withdraw my offer? And the answer is yes, before the other side accepts. So until the other party accepts your offer, you have the ability to rescind that offer. What happens if you say, and my offer will stay open until, you know, Monday. At that point in time, you've made a firm offer and you cannot withdraw it because you've told the party receiving the offer that this offer is good for a certain number of days, a certain number of hours, whatever it may be. So if you make what's called a firm offer, where you say, my offer will be open for 3 days until Tuesday, whatever it may be, then you cannot withdraw. And then this is a little archaic. I mean, I have clients, they're like, I don't own stamps. How do you want me to mail you anything? And so ultimately, there is something that's referred to as the mailbox rule. So it's when do you accept an offer? So I make an offer. I say, do you want to buy my car for $500? Like, let me think about it. And then on, Friday, I drop a letter in the mail, saying I accept. You don't receive this mail until Monday, Tuesday, whatever it may be. But then on Sunday, you call me and say, I'm rescinding. I haven't heard from you yet. And you're like, oh no, my response is in the mail. It's coming. It's postmarked today. And so based on the mailbox rule, as soon as I deposit my letter in the mail, I've accepted that offer, even though the offer or hasn't received my acceptance yet. And then we've already talked about, is the offer open for a certain number of days? Um, but then what about this big thumbs up emoji? There's a case out of Canada that ultimately someone made an offer, and then in reply back in a text, they do a thumbs up. And they're like, what did you thumbs up? Thanks for making the offer. I accept your offer. Right? I mean, so ultimately, a thumbs up emoji could ultimately result in an acceptance. Right? It comes down to what's the intent of the parties. And now you maybe have to bring some outside evidence in to say, what did the parties actually intend here? What did they mean? Um, so you have to be careful, right? Is a response in an email or the back and forth of an email, is that going to be admissible? Is that a writing? You're back and forth in a text message string. Will that be able to be shown that you've accepted? And I think the answer is to yes to both of those, to emails, instant messages, text messages. All of those are writings. You don't need to have a pretty piece of paper that says contract across the top of it to end up binding yourself in a contract. And so these very brief text speak responses that are maybe just a series of letters that says I don't know or whatever it may be, those all could form the basis of a contract that you're going to be bound by. So you do have to be careful. My experience is there's very few scenarios where there needs to be immediate action, that you have to pick up your phone and immediately respond while you're, walking, while you're doing something else and you're distracted. There's very, very, very few scenarios where someone needs an immediate response. Are there situations when someone needs an immediate response? Yes, there are. But is it always? And I think the answer is no. So take your time, make sure you fully understand what you're saying, what you're receiving, what you're responding with, so that if you ever have to defend your position in a court, you're able to put that document up on the overhead screen and then be able to explain it. The goal for a contract is you should be able to give this to a fifth grader and they should say, this is what everyone has agreed to do. The goal is that there's very little interpretation, very little implying that needs to occur, because the hope is that this contract sets expectations. What am I going to deliver? When am I going to deliver it? How much am I going to deliver? What colors? Am I given a warranty? All these things should be spelled out so that at the end of the day, there is no discussion. You're like, this is what you wanted, this is what you got. And so now sometimes I have clients that do want a little wiggle room. They understand that there may be disputes in the future or interpretations in the future, but they've done that on purpose, not by poor drafting. And so ultimately, it is not uncommon to have a provision that's up for debate or up for interpretation, because then both sides have a bit of wiggle room here. The goal is not to have any wiggle room, but if that's the scenario, then yes, you could build that in purposely. So, all right, consideration. What is consideration? Typically, you think of consideration as money. I give you my car, you give me 500 bucks. But does consideration always have to be me giving up something and you giving up cash or money? And the answer is no. Basically, there just needs to be some sort of detriment. You agree not to do something. It could be no different than a non-compete in an employment relationship or a business sale relationship, right? There's not necessarily any additional consideration besides me allowing you to continue to work for me. But because I allow you to continue to work for me, that's sufficient consideration for you to agree to a non-compete or a non-solicitation provision or something like that, because the consideration is I'm continuing to employ you. Because you may come back and say, well, I didn't get any more money, but ultimately they wanted me to sign this non-compete, and your continued employment is the consideration that's provided. Consideration can be, um, I gave you this service and you aren't paying me, so now you're going to give me your car, right? And both sides agree to this. Or ultimately, you're going to come and cut my grass, for the summer because I don't have the cash to pay you. That's also sufficient to be consideration. And then amendments to your contract. This happens all the time, and there's not a problem with it, but it needs to be in writing. It needs to be very clear what changes are being made. Um, and then, just because you want more money or your performance has become more difficult because you misquoted, doesn't mean you can get more money from the other party. If the scenario or facts haven't changed and there's been no changes or no amendments, because then you would have a pre-existing duty to already do the task for the agreed upon amount that you've already agreed upon. But ultimately, could you unwittingly possibly have an amendment? You have a contract, and then you've had a series of email exchanges between the two parties. Could they amend the contract with these emails, even though there's not a formal document that says First Amendment across the top and everyone signs it in their signature block? Could you amend because of text messages or email exchanges? And I think the answer is yes. So you do have to be careful, as to what you're agreeing to in text messages or emails when you do have a contract. And if you are making a change, is this a permanent change, going forward, or is this just for this one activity, this one task, this one unique situation? So making sure that it's very clear as to what this change is going to apply to. Is it payment terms? Are you going from 30 days to 90 days or 60 days? And is that for every invoice or is that just this one invoice? And so ultimately, just so you have a very clear understanding, like I got a contract from that another attorney drafted, and it was sort of like a lease with an option to purchase, and it's kind of a little bit convoluted. It's a little bit goofy situation, and my client was like, "Well, hey, my client's the tenant or possible purchaser." And my client was like, do you have your edits back yet? And I was like, no, I just sent you a page and a half of questions that ultimately I need to be answered, or so that I can then prepare my updates. Because it's not necessarily that my changes are anything radical or my edits are anything radical. It's just trying to get so there's some clarity and understanding as to what all parties have agreed to. Because they're like, hey, I thought you were going to do this. And you're like, when did I say I was going to do that? I never said that. You're like, well, that's what I was assuming. And you're like, well, I think you maybe assumed wrong then. Or if you did want that, then it should have been in the agreement. And so that's what we're trying to prevent is getting a little bit more clarity into the document so everyone's on the same page. And I don't think they're adverse. It's just making, writing the agreement in such a way that as many possibilities that can occur in the future are addressed. So there's some certainty on how to move forward. All right, capacity. Who can be the parties to a contract? Who can sign a contract? In Ohio, you must be 18 or over to be contractually bound by an agreement. So if you're 17, 15, 16, whatever it may be, if you sign a contract, it's going to be unenforceable because one of the elements of the contract is capacity. And ultimately, if you're under 18, you just don't have the legal capacity to sign a contract. And then are you mentally capable? It doesn't mean that just because you maybe have a mental disability, doesn't mean you're not going to be able to contract. It's all an intent issue. It's do you understand what you're getting into and the ramifications of getting into it? And so just because like I have an example, I teach a couple of business law classes at a local college. And one of the examples is, you're drunk. You end up having an agreement that you want to buy something from someone else. And then ultimately the person, comes over to your house and says, okay, where's the $100? You agreed to buy this stuff for me. And you're like, oh no, I was drunk last night. Just because, I think you'd need to bring in more facts, in terms of how drunk were you, or inebriated or whatever it could be. And saying, just because you maybe had too much to drink, does that mean you didn't have the mental capability to understand what you were getting into, right? And then whose definition is drunk? Is it the legal definition for driving? Or is it, I can't get up and walk anymore? So ultimately, you really have to go through and look to say, okay, what was the mental capacity? What was the ability to understand what they were doing in this transaction? And then the last item is the subject matter of the contract legal? Are we even able to contract for this? And one of the examples is going to be, that's to some degree a change, a moving of the goalposts can be this whole kind of marijuana, CBD, hemp, kind of issues and THC and, hey, while this was potentially legal, I entered into a contract, I don't have delivery until June. And you're like, oh, I think Ohio law might have changed. And now, if I, take delivery of this in June, I might be committing a crime, maybe doing something illegal. And so ultimately, if the subject matter of the transaction is not legal on the day you contract, it's an unenforceable contract. If it's a contract that's going to be performed to some degree in the future, and if the law changes and now your subject matter of the contract is illegal, then that's no longer going to be enforceable for the future conduct. But for the most part, it's going to be, you would pretty much be, every contract that I have with a client, I can't remember when I had to give this element of the contract a second thought. Is this really going to be legal? I'm like, is my client allowed to be a dentist? Well, they have a degree to be a dentist, so yes, they can, treat people. But ultimately, I'm a business coach. I don't need any licensing to be a business coach. So yes, I'm going to be able to do that. Not an issue. So for the most part, the legal subject matter is generally not an issue, but it could be. You might have to look and say, what's the status of this, especially now or in the future. All right. What are the types of contracts? So in general, they fall into two buckets. One is a verbal contract and one is a written contract. So I'll have clients say verbal agreements are not enforceable. And I was like, well, there are a couple of situations when they truly are not enforceable. And one is for the sale of goods of $500 or more, then those contracts need to be in writing to be enforceable. And the other contract is a contract dealing with real estate. The sale of real estate contract has to be in writing or it's unenforceable. Leasing of property for more than 3 years for that lease to be enforceable has to be in writing, has to be notarized. And so ultimately, some documents just flat out have to be in writing, won't be enforceable if it's not. Does the writing have to be a nice 8.5 by 11 piece of paper, says contract across the top? It's nice in print, typed, got nice margins, hopefully no typos, etc. And the answer is no. Could you have an enforceable written agreement that you wrote on the bumper of your car? And the answer is yes. What's the problem? Got to take the bumper off, right? I mean, ultimately, what happens if it rains and the ink, runs? Can I have an enforceable written agreement on the back of a napkin in a bar? And the answer is yes. On the back of a pizza box, yes. All of those are writings. You maybe don't have it artfully stated what you've agreed to, but you probably agreed to something. And then are verbal agreements, are oral agreements enforceable? And the answer is if you've made an offer and acceptance, you have consideration, you have capacity, legal subject matter, you don't have one of these types of contracts that have to be in writing, then the answer is going to be yes, it's enforceable. And you're like, but how do you enforce it? You're like, I didn't say it wasn't enforced. I said it's enforceable. I didn't say how difficult it's going to be to enforce. But ultimately, that's going to be the issue is you have the he said, she said issue as to what was said, what was agreed to, what did the parties intend, right? All of those are going to be up for debate. So yes, the agreement is enforceable. The problem is, what are the terms? What are the terms of that agreement going to be? Um, let me just Okay, I'm going to go back one slide. So this stay on this slide. So I just and it maybe it's talked about in the next slide. I just want to quickly look. But ultimately, what happens if you have a contract, or and you maybe you don't have a contract, and then you have a conversation with someone, and then ultimately they're looking for you to do something. They're looking to buy something. You're looking to work together. And you have a very nice conversation with that person, but nothing's in writing. I'm a big fan of memorializing that. At the minimum, it should be, hey, great conversation. Enjoy talking with you. Very good. I'm glad we're working together. And just so I got everything down right, here's what we've agreed to. Here's what we're going to do moving forward, and have a whole list of bullet points as to the items that are really key and important to you. Um, and then it can just be, period, thanks, I'm going to start working. Or do you have a contract there? I think the answer is no, because no one's accepted it. But you at least have an impression or an indication of what the parties agreed to. And then if you did have a dispute and you went to court, which side would you rather be on? The side that sent this detailed listing and said this is going to be a lot of fun. I enjoy working with you. Or would you rather be on the side that says, oh yeah, I got that. Did you agree with it? No, I didn't agree with any of it. Did you do anything about it? No, they didn't ask me to do anything about it, but ultimately you gave them the impression that you've agreed with all this. And so I'd rather be on the side where I prepared the summary and sent it to the other party than being the other party that says, oh, yeah, I got it and it was all wrong. And did you do anything about it? Nope, I just sat on my hands and did nothing. And so there's going to be almost an interpretation that those were the terms and you just never rejected. But if you really wanted to have clarity and you want to have an offer and acceptance, you do the exact same memo, exact same bullet points, and then you say, I am not going to start until you reply back and say, we have a deal and you accept. And then you've made the offer, and then the other side replies back and says, yes, this is all correct. Please move forward. Now we got an acceptance. Now we have our contract. So ultimately, you have two routes to go. One can just be memorializing for the future, and then the other can be, I'm not going to do anything until you hit reply and accept. So I'm very comfortable about how we're moving forward here. All right, written contracts. What's the purpose of those? Right? It's going to be your formal contract with the other side. And again, like I mentioned earlier, it's there for clarity, it's there for expectations. In any type of situation, when do things seem to go sideways, go off the rails. People get mad at each other. A lot of times it's with expectations. What did you expect I was going to do? What did you think I was going to do? Why would you think I was going to do that? That is completely unreasonable of you of think that I was going to do X, Y, or Z. And so this creates a set of expectations. When are you going to provide your service? Are you giving them a warranty with the service that you're providing? How long is the warranty? You know, all these types of things are going to be items that are in the contract. The contract doesn't have to be overly burdensome. Many times there's a whole bunch of provisions in the contract that are sort of boilerplate. What law is going to apply? Are we going to have a jury trial? All these types of things. But ultimately, the most important is probably two or three paragraphs. And that's really what the service is that you're going to be providing, the products you're going to be providing, when are you providing it? So ultimately, that should be the goal of the written contract. is making sure everyone is very clear as to what is being provided here. And then I already mentioned about the phone calls and following up with emails or text messages, which I think are really important. It makes sure everyone's on the same page and I didn't mishear something. And then it also gives you a little bit of wiggle room. You know, if you come back and say, "Oh yeah, no, I don't think I meant to agree to that. Here's what I did mean to agree to," or propose, you can make those edits or changes after you have a chance to think about it. All right, contract content. Um, I think this is a big deal, you know, and it has nothing to do with artificial intelligence because you could have bought contracts from Office Max and Staples years ago. You can do a search for a contract on the internet and you'll be able to find it. Um, and then you can do a search on, you know, in artificial intelligence and say, create this agreement for me, blah. And then it just spits something out. And the issue is, do you understand what's in the contract that you're going to sign? Do you understand every provision that's in the agreement and why it's there and the purpose for it and how it can be drafted differently? Um, I mean, it's no secret, depending on who I represent, will depend on how I put my thumb on the scale when I draft the agreement, right? Ultimately, do I have a provision that says, that's a little bit more forgiving when I'm the party doing the performing, and as opposed to something that's maybe very strict when I'm the party receiving the performance to make sure, I'm getting exactly what I wanted. It couldn't be, when I'm helping someone buy a piece of commercial property. There's different types of deeds that I can insert into the agreement. If I'm the buyer, probably want a general warranty deed. If I'm the seller, probably want a limited warranty deed. And it ultimately determines how much liability I have going backwards in time, if there ends up being a problem with the title. A general warranty deed is what you typically get when you buy a house. Um, and that is, I'm as the seller, I'm going to make sure I give you good title from the day that was platted in the 1800s. I'm going to make sure there's good title. But a limited warranty deed means as a seller, I am only going to ensure that you get good title for the time period that I own the property. So if I bought this property in 2020 and then there's a problem with the title in 2016, that's not going to be my responsibility, because I'm only guaranteeing you good title as I owned it. Um, so ultimately there are different provisions that you can draft. And there's times that my client tells me, hey, draft it, hit it down the middle, draft it fair for both sides. And because that's, we just want this to be a fair transaction, no big deal. And I'm like, okay, fine. You're right. I mean, I have that ability to do that. And then no blanks. If you sign a document that has blanks in it and you haven't filled them in, then the other side can fill them in at your peril. You've ultimately ceded the authority on how those blanks will be completed, and the other party can just unilaterally put something into that blank, and you're going to be bound by it as long as it's not something completely unreasonable. But in general, you do not want to be signing documents that have blanks in them. You want to make sure that those blanks are filled in before you sign. All right, contract content and AI forms off the internet. Talked about it a little bit. If again, we're looking at the elements of a contract, and if whether you pull a document off the internet or you use artificial intelligence to draft something, if you meet all the elements of a contract and you sign and everyone signs it properly, then you're going to have a formal binding agreement, whether you understand what is in there or not. So do I use, artificial intelligence dealing with contract stuff? Periodically, I do. Typically, I'll maybe use it when I'm trying to figure out a particular provision. It's kind of a goofy provision, a one-off provision that I maybe haven't used before or experienced before. And maybe I'll put in a super long prompt to try to come up with a provision that'll fit that scenario. And then I'll get something, I'll clean it up. So I've just kind of played around and I've said, hey, provide me with a blank, blank, blank type of agreement, and I'll get something that's like about a page and a half or 2 pages long. And for the most part, it's garbage. It's just not good. What's the purpose of artificial intelligence? And there's a ton of debate about this, amongst attorneys and other professionals. And could artificial intelligence be to the point where it's as good as a professional? And I think the answer is At some point in time? Very well likely. Today, is it at the point where you can replace a professional with artificial intelligence? And I think the answer is not even close. Artificial intelligence, especially in the legal world, is akin to um, possibly a paralegal, a law clerk, an intern, something that can give me a start that I will then update and continue review. But if I provided you, if I said, oh, I'm just going to mail this in, I'm not going to do any work, and I'm going to use AI to draft my contract, and I'm going to not edit it and give it to my client, if my opinion, that's probably malpractice, just because it's just not good. Um, because I've gotten documents from the other side, maybe when they're unrepresented, and I'm like, I'm not even reviewing it. It's going to take me more time to review and edit your document that you provided me, presumably created by artificial intelligence, as opposed to just drafting it from the beginning. It's just not there. Because I mean, if you wanted to prepare an agreement, that say the agreement's 13 pages long, your prompt would have to be pages long, maybe more than one page, probably 2 pages of prompts to come up with an agreement that's going to be relatively satisfactory. It's just that the technology is just too new. And I think you really have to be careful using it because and also if you ask AI questions, legal questions, give me an answer. Um, it makes a declarative statement usually, and it maybe even gives you case law that says, here's the answer. And because of that declarative statement, instead of going, I don't know, you have to look it up more, proceed at your own caution. And because the AI gives you this response that looks so sure of itself, that most of the times it's not right. Like I had a client, we were on the phone. He they were looking to they have a liquor permit. They were in one business, they were looking to start a different type of business that required a different type of liquor permit in a different class. And I'm like, you can't do it. Because you can't be a business owner's, the same business owner can't have, just based on Ohio liquor laws, you can't have permits in two different classes, just based on Ohio liquor laws. Ohio liquor laws are basically no different than during Prohibition. And then ultimately the client goes a couple minutes, like a minute later, goes, oh, no, 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 we can do this. I'm like, you just typed it into AI and asked, didn't you? He was like, yeah, how'd you know? I go, because it's not right. It is not even close to being right. And that's the scary part, is they were going to invest $250,000 in this business while they're trying to get approval for the liquor permit, and they were never going to be able to get it. They would have wasted $250,000 on this business that they wouldn't be able to operate. So you really, really, really have to be careful. AI is an assistant. It's not a replacement. And the problem is if you don't know when it's right and when it's wrong, or the questions to ask, if it's right or wrong, or doing additional research, that's where the concern comes in. So, all right, that's my AI rant for the day. All right, payment terms. Quite frankly, I think the most important of everything, because ultimately you're doing all this work as the business owner, and cash flow is king. When am I going to get paid? How am I going to get paid? What's the frequency of payments? So this needs to be very clear. Do you need a down payment? Um, are you going to have a big, say you're building a website, it's going to be $8,000. Are you going to, just say, okay, I'll see you in 3 weeks and then give me 8 grand. And the other side comes back and goes, wow, that is not what I wanted. And you're like, well, yeah, you told me this is what you want. You're like, no, I never said this. And now you got a dispute. And now you're owed 8 grand in 3 weeks worth of work. And so, having progress payments, having break points where you continually check in with the other side. And if the other side, maybe you have two, three, four, five break points, and every time, let's say you have five, and every time you reach a milestone, the client accepts, and then they pay you 20%. Or something like that. So that now at the end, if they're not happy with the final work product, now you're only looking for 20% of the final payment as opposed to 100. And so this cash flow is very important. Um, and so, I tell, I had someone in construction, they're like, oh yeah, I'll just bill you when I'm done. I'm like, well, when's that going to be? Oh, 6 weeks. I'm like, do you have subcontractors you have to pay? He's like, oh yeah, I pay them, once a week. And I'm like, so you're going to front this money for 6 weeks and then you're going to ask for 40 grand from the homeowner? I'm like, why don't you ask for a down payment, ask for money for materials, ask for progress payments every time you get to a different break point? And they look at it like, yep, thumbs up, this looks good. And so it just, you want to minimize the amount of money that is due to you at the end of the project. I have friends of mine that are attorneys. I'm like, so when do you ever talk about legal fees, how much it's going to cost or projected cost for a project? They're like, I never do. I'm like, well, why? They're like, oh my gosh, I just don't bring it up. I'm like, but you don't think your client's thinking about it? Like, how much is this going to cost me? And I'm like, to my best ability, I try to talk about it up front before they hire me. Because I had a client, they're like, will you review this document for me? I'm like, yeah, and then I'll give you a memo and maybe make some edits. They're like, how much is it going to be? I'm like, oh, it shouldn't be much, $300. They're like, oh, like $300. And I'm like, well, you asked for a quote. What did you think it was going to be? They're like, well, not 300. And I'm like, I mean, that's maybe even a discount, to help you with this project. They're like, "Pfft." Like, so it's way easier for the client to say no, thank you, whether it's 300, 3,000 or whatever, than for me to send a bill and the client's like, wow, that wasn't worth it. And so I'd rather have a client say no, thank you, it's not necessary, as opposed to then having an unsatisfied client saying, I think I charged too much. And then it's a collections issue, and who wants to deal with that? And so my experience has been, when I tell a client, this is going to be 5 or 6 or $700 or whatever, and then they get a bill for 5 or 6 or $700, they never have a problem paying it because that's what they expected. So setting that expectation early on is important. And then, especially in the construction industry, there's these pay when paid, pay if paid policies or payment terms, and they are enforceable. So pay if paid sort of is what it sounds like. If me as the general contractor, if my client doesn't pay me, even though your work was stellar, thumbs up, nice job, I'm not paying you, subcontractor, because a condition precedent of you getting paid as the subcontractor is I get paid from the customer. And so you really have to be careful about if there's a provision of pay if paid in there, because that means you as the subcontractor are the one holding all the risk. Pay when paid is a little different. It is, subcontractor, I'll pay you when my customer pays me, but in no event I will pay you within a reasonable time. Now, what's a reasonable time? I have to look at the industry. I don't know, 14, 30, 60, 90 days. I don't know. Depends on what the industry is, but you will get paid in full. It's just you may not get paid on your timeline. And so while pay when paid is better than pay if paid, pay when paid doesn't give you a date certain that you're going to get paid. So you do have to be careful when you see these payment terms because you may say, hey, I'm going to send you an invoice and you pay me within 14 days. But ultimately, if the clause is pay when paid, they'll pay you when they get paid, or the general contractor will pay you um, within a reasonable time, which may not be your 14-day time period. You're like, well, I got bills to pay, I got people to pay, I got materials I've bought. So you really have to be careful on these payment terms. And again, if you read an agreement and you don't understand it, you need to make sure you ask the questions, to so you can get that information so you understand what you're how you're going to get paid for the work that you've done. And then just like a public service announcement, attorneys, um, we haven't done a great job of focusing our practice on certain areas of law where doctors, they are very specialized. You go to potentially a doctor and they're like, oh no, 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 no. This is a foot problem. You're like, yeah, that's a pinky toe. I only deal with the big toe, right? I don't deal with the pinky. You need to see a different doctor for the pinky toe. I don't deal with it, right? I focus on the big toe and that's it. Where a lawyer, you can go talk to them and you're like, I have a bunch of problems. I have a divorce I need. I have child support. I got a DUI. Um, I have a contract. I'd like to file for a trademark. And I have this commercial building I'm looking to sell. Can you help me? Like, I can do it all. You're like, really? And you're like, I've never done a divorce before, never helped anyone get out of a DUI or deal with a DUI. And so so when you go to hire an attorney, you just have to ask them, you have to do a couple of things, ask a couple of questions. How many times have you done this transaction in the last year or in the last 2 years? And then ultimately also go to their website. And usually they'll have a website, it'll say, services offered. And if one of the items you're looking for is not listed on their website, then that means that, in my opinion, that's not one of their core competencies. That's not something they do often and frequent. And so, can they help you with that? Can I help you with almost any type of area of law? And the answer is yes. There's a very few areas of law I can't do. One of them's a patent, a death penalty case. There's very few areas of law that I am not qualified legally to assist you in. But ultimately, you want to, retain an attorney that they do this frequently because it's not necessarily that they'll commit malpractice by representing you in this, but I think you're just not going to get the richness or depth of legal representation that you would from someone who does this regularly. Because you don't necessarily, when you're not working in this area of law often, you don't know when the other side is um, exaggerating, a provision or a position they're taking. You don't know what's typically standard or normal in that particular matter, or that situation. So you're just losing out a little bit of the depth that I think you would normally get when you hire an attorney that does this work all the time. And I refer people out all the time to other attorneys. I don't do litigation, never want to step foot in a room again, and I'm super happy about it. And there's other attorneys I know that love to litigate. I'm like, you have at it. No thanks. So, and also ask how much is this going to cost me at the end of the day? So. All right, I am done with my legal speak. I guess I can maybe I can stop sharing, I guess.
Yeah.
Um,
Yeah. We do have a few questions.
oh, here we go. How do I stop sharing? There we go. And then there's
Okay.
some questions I can go through. Yeah, I tried to do this once before where I was answering questions while I was trying to talk and it wasn't working.
Okay. Okay.
So
All right.
I can
Eric has a couple questions. One is, can you say a few words about implied consent and what you need to be careful of?
implied consent. Well, that would be you don't have a contract, and based on your actions, it appears that you accepted the contract. Um, you're right. You don't have a formal agreement where the terms are expressed, where both sides have signed. So an applied consent situation could be like the very first example or second example I gave, where um, I'll give you $500 if you drive the car to Akron. And so I guess you would say implied consent would be I actually drove the car to Akron. Um,
Right.
and so that's one scenario. I guess another would be, you know, there was a discussion about a party doing something, cutting your grass, and you don't have a formal contract. And then the person comes over and starts cutting your lawn, and you see them cutting your lawn, and you don't stop them. You're like, why is this person cutting my grass? I didn't want them here. I was going to do it myself. But the fact that you saw them doing it and you didn't stop them, I would assume that means you've implicitly agreed that, you're going to let them cut your lawn and then you're going to pay them for it. Um, so again, that comes into, not getting yourself into a situation where things aren't properly drafted or written. And again, the writing can be an email or a text message. It doesn't have to be something formal on a piece of paper. So.
Okay. Okay. Eric has another question. Let's see, what steps should be taken if one is given a contract that is unacceptable and you have no intent on agreeing to? I think that's a pretty easy one, I think.
Yeah, I mean, ultimately, if a party provides you with um, an agreement and you don't agree with the terms, then you just don't sign it, right? And you
Yeah.
negotiate back to
Yeah.
say, this is what I'm willing to agree upon. I don't agree with your terms that you've proposed, and here's what am replying with or responding with. And then you have your negotiation, your back and forth, um, to ultimately determine if you can come to an agreement on what the final terms are. So if a party gives you an agreement and you're like, oh boy, I don't agree with any of this. Right? I mean, is that something you're going to sign? And the answer is no. And that's the difference between litigation and business contracts is no one can force you to sign an agreement, right? You have to want to do that voluntarily and intend to do it, right? Like, you're like, okay, ultimately, you kidnap my kid, and you're like, I'm only going to give you the kid back if you cut my lawn, and you're like, well, I don't want to cut your lawn, but I want my kid back, so I guess I'm going to cut your lawn. And you're like, well, that's like, I didn't mean to. I had no intent here. It was duress, or, it's an absurd of example. But ultimately, no one can force you to, agree to a term of a contract. You have to voluntarily do that.
Right.
And if you
Right.
don't agree with the term, then you don't agree with the contract.
Yeah, in the old days, I remember where you would before the internet, where you would scratch out something that you didn't care for, and you'd initial it, and then the originator would initial it too. Does that still happen now?
Yeah, you see that a lot on pre-printed residential real estate forms. They have their form that the real estate agent provides to a buyer, and then the seller provides the buyer with an offer that's signed. And if the buyer doesn't agree to a term, then the buyer scratches it out, writes something else in, initials it, gives it back. But that's pretty clunky. Especially now with Word being able to track your changes directly in a Word document. There's no reason to have all that and that all those scratchings out and initialing in a contract. You should be able to, at the end of the day, propose your edits back. Like I get that a lot from people send me PDF documents. And I'm like, I assume that you had to create this in Word. So just send me the Word document. I'll review it, update it, make changes, and I'll send you back a Word document that you can review and update, and then we'll finalize it in a PDF and sign it. You can convert a PDF into a Word document, kind of clunky, formatting gets all messed up, but you can. I have, unless it's locked down because of a DocuSign or something, I can edit a PDF. So
Right.
there's a lot of ability to make edits and have a clean document at the end of the day that everyone has signed.
Another question is how do you find like a lawyer that specializes in contracts?
Again, you would do a search.
Okay.
That would be your internet search when you're looking for a lawyer that has that specific background. Business transactions, contract drafting, contract review. You could talk to friends of yours that have hired attorneys in the past and ask them if they know a business lawyer. In general, if you talk to and you say, I need a business lawyer, that person probably has familiarity with contracts because that's all business law is contracts for the most part. Um, and then you can contact your local bar association. They generally have an attorney referral service. You can ask for a business attorney or attorney that does assist with contracts. But it may be difficult for you to specifically say, I want a contract attorney. You may have to say, I want a business attorney, and then tell them the exact situation that you're looking for and see if that attorney is familiar with it. Because not
Okay.
every contract's built the same. Not every industry is the same. Some industries have uniqueness, like the medical industry, some other ones. So.
Okay. Sabrina has a question if there's any difference between a contract and a permit.
A contract is just an agreement between potentially two parties to do something, where a permit, in my experience, is generally going to be, provided to you from a governmental entity that says you're permitted to do something. Like you cannot start, this building project until, you have a permit, then ultimately now since you pulled a permit, now we know that you're doing some sort of construction, then we can come back in and check the electrical, check the plumbing before, the project is finalized. So a permit and a contractor have served different functions. The permit
Okay.
is going to be generally issued by a government allowing something to occur, in my experience.
Okay. That's cool. All right. Catherine has a question here. Could you touch on the when UCC applies? Can you touch on when UCC applies?
Yeah, so the UCC
Also,
is, go ahead.
could you discuss click agreements on the computer? That's a good question.
So UCC, that stands for Uniform Commercial Code. Ohio has adopted the Uniform Commercial Code. Ohio's legislature has. And that is the Uniform Commercial Code is a series of laws that apply between basically, commercial businesses. And it's just a framework of how contracts are going to be reviewed and interpreted. So if it's going to be a contract between, you know, a roofing company and a homeowner, the Uniform Commercial Code is not going to apply because the customer is a consumer, not another business. And it also has to be for the sale of goods. So generally, you're going to have the Uniform Commercial Code applying. You would presume it's going to apply when you're doing business contracts. There may be exceptions when it doesn't apply, but the Uniform Commercial Code is going to apply when you have transactions between two business owners for the most part. And then a
Okay.
click-on agreement, that's basically you're shopping on the internet and you want to buy something, and you have your shopping cart full of stuff. And before you can enter in your credit card information, that little dialog box pops up and says, before you can enter your credit card information, you have to click I accept on these terms and conditions. If you don't click I accept, you never get taken to the payment portal. So ultimately, in order for you to put your credit card information to buy, you have to accept their terms and conditions. That's your click on agreement.
Okay.
And so, does anyone ever read those terms and conditions? No, everyone just clicks on it because they know they can't buy if they don't click. So,
Right.
but it's important that that click happens before they purchase. If they purchase and then the box pops up to say agree to these terms and conditions, those terms and conditions will not be enforceable because the terms of the deal have already been set at the time that payment was made. That's why that click box always pops up before you enter your payment information.
Okay. We have three questions, all about generic catering contracts. Is there someplace you'd recommend they go, or any thoughts on that?
It's ultimately, again, it comes down to, I think, what services are being provided and what aren't. What is part of a flat fee and what is a la carte. So I do think it's, important to ultimately determine what is being purchased and when.
Right.
And,
Right.
is silverware included? Are the heating canisters included? I mean, how much is being included as a flat fee, and then how much
Right.
is being
Right.
is going to be add-on or a la carte? And then, so do you have the ability to refund? Does the person have the ability to cancel? You're like, oh no, I mean, I already bought the food to be able to prepare, and so no, at a certain point, you cannot cancel. So it's like those types of terms are the ones that you would want to, make sure are clear.
Okay. Okay.
And you know what? And if you and insurance is important, having commercial business insurance is important. And you cannot get business insurance for a breach of contract, but you can for negligence if you made a mistake. So many times when you um, get your commercial insurance, you could also ask that commercial insurance agent, I have my contract. Do you have any service within your insurance agency where the underwriters will review the contract to make sure, that I'm properly protecting myself and, not opening my business up to exposure.
Right.
And there are some insurance companies that do have an underwriting service where they will agree to review your contract. Not all of them, but you can ask the question. And
Right.
they're looking
Right.
at it from the insurance liability side, not from this is a clear, concise agreement, but it can help.
Okay. Okay. Chris, thank you very much. It's 2 minutes till. We're running a little bit early. Thank you for your time and for sharing. Let's see. Let's see. I think we covered that. Okay. Couple last minute here. What should be included in a NDA to cover my product was one question.
I guess it depends on, are you looking to have someone help you build your prototype? Then,
Mm-hmm.
I mean, you'd want to make sure that, any intellectual property, that's generated from your product is, coming to your benefit, and the other side is not going to be able to improve on your product and try to get a patent on the improvement. So you
Mm-hmm.
really, if you do have, a product, especially if you think it's, something that has a patent to it, my recommendation is, seek out a patent attorney, and make sure your NDAs are going to be properly, addressing all of that product development related issue. But confidentiality agreements are important, and non-disclosure agreements are important, especially when you're going to be. It doesn't have to just be a product. It can be a business idea. It could be a marketing plan. It could be something that you think derives value that, because you have it and no one else knows it. And so those, you're going to be hiring people to help you with that. Could be your secret sauce, your recipe, right? I mean, so having a non-disclosure agreement where people aren't going to use your internal business information for their own purposes is important.
Okay. We got an anonymous question here, and it's going to be our last one, I think. Is it necessary to use a lawyer when contracting with a registered agency? I'm not sure I totally understand that.
You never have to use a lawyer for anything. I mean, that's going to be your choice.
Okay.
So, yeah,
Okay.
so I'm not sure. I agree with you. I don't understand what a registered agency means,
Yeah.
but
Yeah.
ultimately, no. Do you need to hire a lawyer to do anything relating your business? And the answer is probably no. As long as you're
Yeah.
attempting to represent some other party, and then you maybe have an unauthorized practice of law issue. But my what I've typically seen is business owners and people try to wing it until there's a problem because they're like, well, I
Right.
don't have a problem until you have one. And then generally it's way more expensive to undo the problem than if you hired an attorney that's experienced in that issue to address it the first time.
Right.
That's been
Right.
my experience. Like
Right.
I had a client, someone else, provided the business owners with an operating agreement. The operating agreement wasn't close to being right. My fee would have been less than $1,000 to get them the operating agreement they needed, and I probably charged them over 3,000 to try to
Right.
resolve an
To
issue.
fix it. Yeah.
It was
Yeah.
just you just get short-sighted.
Yeah.
Um,
Yeah.
but a lot of
Well,
times you
you
don't know it until you've experienced your first problem, or you know someone who's experienced a problem.
okay. All right. Chris, thank you for your time.
Right.
Thanks for sharing your views on contracts and everyone else. Have everybody have a great weekend.
Right.
Thank
Good
you.
day.
So long.
All right. Thanks, everyone.